And on this morning's Ag Issues program, it's a pleasure, as always, to bring on to the program Roger McEowen, professor of agricultural law and taxation at the Washburn University School of Law. You also hear him a little after 5:30 on the Agricultural Law and Tax Report as well, as he joins us on the program this morning. Roger, good morning. How are you?
Good morning, Greg. I'm fine, thank you.
Well, I appreciate it, as always, coming on to the program. And first, want to talk about that you just recently returned. You had a speaking trip that took you through several states in the West. And, of course, while we've seen a fair amount of rainfall in many areas of our state, of course, we all know what's going on out West. And you had a chance, first off, to see that firsthand as well. But that also relates to the first topic we're going to discuss, and that's, of course, for livestock owners on what they're going to do as far as their cattle are concerned, or weather-related sales of livestock, and just some things to remind those who may come into that situation.
Yeah, that's right, Greg. And it's always amazing to me, it always has been, how the agricultural issues, the legal and tax issues differ from parts of the country to other parts of the country. And while we're not thinking too much in the eastern third of Kansas this year, or in much of Kansas this year, about drought issues, it is a big issue out west. We went through many, many parts that are very parched. Central Wyoming and parts of Idaho and Montana, vegetation is just sapped. They really need moisture. And then, of course, you add in the smoke from the fires coming down from Canada and from the Pacific Coast area, Oregon, Washington, and California. And the haze from the smoke, I've never seen it this bad. And I've been going out west many, many times since I was a kid. I have no recollection of the smoke ever being this bad. My 2-day conference was in Missoula, Montana, and Montana is surrounded by mountains all the way around. It kind of sits down in a bowl, and you really could not see the mountains around the town from town. All you saw was white haze. It was that bad. And I felt bad for some of the people that had come from many parts of the country, that this was their first time out west, and they really couldn't enjoy the sights like I know they're there, and that's why I have the conference in these places. It's just terrible. But you're right. This does bring up a tax issue, and that is, if you have to sell more livestock than you normally do you have to report all of the income from that excess number in the year of sale? And there's a couple of ways we can get around that, and we can postpone that gain.
And one to talk about our first one to talk about as far as those provisions, looking at called involuntary conversions.
Yeah, that's right. This is one of the two statutory deferral strategies that we have in the code, and one is to treat the sale of the excess number of livestock as an involuntary conversion. So if you've got livestock, poultry don't count for this, but if they're held for draft dairy or breeding purposes and you sell more than you normally would in the time period in a particular tax year, then that's the sale or exchange of that excess number. We can treat that as a non-taxable involuntary conversion if the sale occurs because of drought or other weather-related conditions. So it could be flood, fire, or anything. It used to be just the drought sale rule, but now, a number of years ago, it was opened up to cover all weather-related conditions. Now, if you do that, and you use the involuntary conversion rules, then you have to replace the excess animals that were sold within 2 years after the year in which the proceeds were received for their sale with livestock that are similar or related in service or use. In other words, if you sell off excess dairy cows, you have to replace them with dairy cows. And so that's the way that provision works. And you have to hold them for the same purpose that the animals given away or exchanged were held. So that's why, for example, dairy cows can be replaced with dairy cows, but they can't be replaced with breeding animals. But there are some other rules to this. Congress loosened this up a number of years ago and said, well, if it's not feasible for you to reinvest those proceeds in property similar or related in use, but simply because they're they're not available to you because of what's going on in the market, then you can reinvest those proceeds in other property that's used for farming purposes, not real estate, but tractors, combines, and those type things. If you do that, when they lengthened the 2-year period out to replace with like-kind animals to 4 years, and that was because of extended drought in western Kansas a number of years ago. They said, oh, okay, maybe you can't replace in 2 years, but if you're replacing with like-kind livestock, we're going to give you 4 years. But if it's not feasible to replace with like-kind livestock and you replace it with a tractor or combine, you got to do that in 2 years. So it gets really confusing fast. But what people need to know is this is one of the two provisions that allows you to postpone the reporting of the gain. You're not going to have to report the gain on the excess number of livestock sold or exchanged right up front in the year that you do that. You can postpone it for when you then exchange the animals you replaced with. So that might be a few years down the road. The thinking is that things will be better by then, and you can pay the tax on the gain in that later year. Because the idea here is we don't want to have a farmer or a rancher in a bad year economically, and then they incur more tax and they don't have the money to pay the tax with. So this is why you're able to postpone that gain. That's one of the two provisions.
And the other one to look at is taking a 1-year deferral.
Yeah, that's just simply we're going to report the gain next year. If I'm on the cash method of accounting and I'm forced because of drought or other weather-related condition to dispose of livestock, now the livestock for this purpose has to be raised or purchased animals that are held either for resale or for productive use. And I sell more than I normally would under usual business practices, then I can defer the gain associated with the excess only until the following tax year. So there are a number of requirements that have to be satisfied to use that rule. Your principal business has to be farming, so forth and so on. But you can use the 1-year deferral provision. This is not a replacement provision. You don't have to replace with similar livestock. So there's no 2 or 4 year replacement rule that you're under. This one's easier, and it's easier to report it because we're not talking about amending returns. As you would with perhaps with an involuntary conversion type treatment. It's just a 1-year deferral. But there are different requirements that apply to each one of these situations. So people need to talk to their tax preparers about this and make sure they have the right kind of livestock for the provision that they're using, what the rule covers, what the rule allows. Make sure you are within the cause of sale, which has to be weather related. Do you have to have a disaster declaration? You do for the 1-year deferral provision. You don't for the involuntary conversion provision. Is a repurchase required? It is with the involuntary conversion provision. What do you do with your income tax basis? That's an issue if you have replacement animals, if you're using involuntary conversion. So there's, and the type of livestock that qualify and what's your replacement period. There's just a whole lot of requirements that can apply to either of these or both of these tax provisions. But the point is that when we get into this situation, and this can be a big issue in Kansas, unfortunately it's not a huge issue this year, but a lot of the West it is, that fortunately there are these two provisions that can help ease some of the tax pain.
Roger McEowen, professor of agricultural law and taxation at the Washburn University School of Law, joins us. And Roger, we go out to the state of California, and you have talked about Proposition 12 a lot. We've talked about it in our agriculture news periodically, but it was a recent court decision by the Court of Appeals for the Ninth Circuit concerning Proposition 12.
Yeah, here we go again with the U.S. Court of Appeals for the Ninth Circuit, and those in agriculture are pretty familiar that this court usually gets it wrong, and gets it wrong often with respect to agriculture. And what did they do this time? Well, what they did was in dealing with Proposition 12, they upheld it, and I'll explain what that is in just a moment, but the impact of this is not just restricted to California or those states that comprise the Ninth Circuit, which are primarily out west. It's going to have an impact on hog production in particular all across the country, and probably the estimate is it'll double the cost of a hog production facility to come into compliance with the requirements of Proposition 12. What Proposition 12 is, if we go back to 2018, California voters passed this, and it bans the sale, and I'm going to look at pork exclusively, but there are other types of products that are picked up in it. But it bans the sale of whole pork meat, no matter where it's produced, from animals confined in a manner inconsistent with California's regulatory standards. I call this the hokey pokey law. And if you remember the song, the hokey pokey, if you stand up, you got to be able to, stand up, turn around, and shake yourself, those types of things. And that's what they're saying here in terms of the way hogs are produced. They have to have a large enough cage, have to be able to get up, stand around, or turn around, do those types of things, hence the hokey pokey law. And it's on the purported goal of increasing food safety and decreasing the risk of foodborne illnesses, and a negative fiscal impact on California that has to deal with those higher rates of illnesses and so forth. So that's their purported reason for it. So they're saying no matter where you produce pork, anywhere in the country, no matter what your state laws are, no matter what the federal government regulatory scheme is for dealing with foodborne illnesses and health and safety of people, which there are a lot of federal regulations on this. We, California, have our own rules, and you're not going to be able to sell into our massive market unless you obey our rules. So it's one state dictating ag practices in all the other states. And the Ninth Circuit Court of Appeals said that's okay. And what it involves is a very detailed legal doctrine involving the Commerce Clause of the U.S. Constitution, Article 1, Section 8, and then a judicially created doctrine rolled into that known as the Dormant Commerce Clause, which we have a couple of justices that don't even believe that it exists, that it's nonsense. But without getting too much in the weeds on this, the Congress, when they put the Commerce Clause in the Constitution, said we don't want one state being able to economically cannibalize another state. And so that's what they're basically doing with the Commerce Clause. And there's a lot of cases concerning this going back well over 100 years, over 200 years. We got a very prominent case in 1829 on this that says that the grant of federal power implies a corresponding restriction on state power. That's, Congress regulates international or national commerce in the country. That's up to the federal government, and states, you can't come in and undercut that. Now, I'm kind of paraphrasing that and simplifying that. But also it says, the Commerce Clause says, if Congress doesn't say anything on particular conduct, then states can regulate. But then the Dormant Commerce Clause comes in and say, well, not so much. We don't want you to regulate in an area that discriminates against the economic activity in another state. Well, you'd say, well, how in the world can California do this, impose higher costs on pork producers elsewhere outside the country just to gain access to their market? And really, I think what this case came down to was a tactical mistake by the lawyers that were arguing this case. They focused their argument on an allegation that Proposition 12 has an impermissible extraterritorial effect of regulating prices in states other than California, and therefore was per se unconstitutional. Now, when you make a per se unconstitutional argument, you better have pretty solid evidence that you have a clear constitutional violation. It's a lot easier to get into something that's not a per se violation, but unreasonably impacts commerce in other states. But they went for the whole ball of wax here, and they missed it. That was a tactical mistake. The Ninth Circuit said that existing Supreme Court precedent on the extraterritorial principle applied only to state laws that are price control or price affirmation statutes. And they looked at this and they said, well, California's not setting a price. All they're saying is the way that you have to produce things to comply with their regulations. So it's not a price control. It's not a price affirmation statute. So in other words, it didn't dictate the price of pork products or tie the price of pork products sold in California to out-of-state prices. So it didn't have, the Proposition 12 didn't have the extraterritorial effect of regulating prices in other states, although I would argue it has the effect of regulating the price of pork products everywhere. You're going to increase the cost of production. The estimate is it's a 9.2% increase in production costs that are going to be passed on to consumers. And they said, in effect, they're saying that's not a substantial burden on interstate commerce in violation of the Dormant Commerce Clause. And they also ignored the court ignored the economics of pork production, of the supply chains in the process. Frankly, it's a messed up opinion by judges that don't have any understanding of agriculture. And it's unfortunate the way that the lawyers for the farm groups involved argued this. And now we're going to have to rely on the U.S. Supreme Court taking up the case. If they're asked, they'll have to decide whether they want to hear the case, and then waiting for what an opinion is. But I'm not optimistic that the Supreme Court would get this right, because they have not been clear on Dormant Commerce Clause doctrine in recent years. And by the time they get to it, this law is going to take effect. It takes effect January 1, 2022, unless some emergency stay would be put in by the U.S. Supreme Court. I'm just not terribly optimistic about this, but here we go again, California setting standards for the rest of the country on production of agricultural products.
Roger, one final thing. The Washburn University School of Law, they're going to be presenting an agricultural law summit coming up in the early part of next month.
Yeah, September 3, Friday, September 3 up at Mahoney State Park, Ashland, Nebraska, which is about equidistant between Lincoln and Omaha, right along the Platte River there, just north of I-80. And this is our Ag Law Summit. We call it Tax and Regulation in Rural America. I do have a link for that posted on my website. I'd encourage people that might have an interest in this to take a look at that. We're going to talk about a number of things: tax, legislation, policy, what's going on in the Congress. A lot of farmers and ranchers are concerned about that. Where's the federal estate tax exemption going to be set at? What about capital gains, corporate income tax basis? And then we're going to survey current and proposed state laws affecting agriculture in rural America, and then get into succession planning, continuity planning. Our luncheon speaker is Janet Bailey. A lot of our listeners know who Janet is. She's been involved in agriculture in the state of Kansas for many, many years. She's also a former student of mine. And then I'll talk about special use valuation, and then we'll conclude the day with kind of a toolkit for practitioners. What do you do for your farm clients in dealing with pretty common business and tax issues in the use of limited liability companies? So I'd encourage anybody that's interested in that. It's also going to be online, broadcast live, so you don't have to actually be in Ashland, Nebraska at Mahoney State Park, but you can be there present in person or participate online.
All right, sounds good. Roger, as always, appreciate it. Great conversation once again, and we'll talk to you here in a couple of weeks.
Thank you, Greg.
That is Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law. He's been our guest on the Ag Issues program here on 580 WIBW.